There. I am so excited to give you this news today. The decision about the Emergencies Act case just came in today, and I can't believe it, but we won. So 2 years to the day of the beginning of the 2022 Freedom Convoy, the federal court has declared that the Trudeau government's response to that protest was unreasonable and unconstitutional. The case was heard by Justice Mosley of the federal court, and today he issued a decision in a group of cases challenging the invocation of the Emergencies Act. Those cases were brought by us at the Canadian Constitution Foundation, by the Canadian Civil Liberties Association, as well as by individual protesters who had been directly impacted by the emergency orders. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine, and I'm the litigation director at the legal charity, the Canadian Constitution Foundation, where we fight for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. Also, please remember nothing in my videos is ever legal advice. If you have your own legal question or problem, please consult your own lawyer. So this decision came out, it's 190 pages. It is extremely gratifying for civil libertarians, but frankly, for Canadians of all political stripes who understand the value of public protest in a democracy, and we understand the dangers of governments using a massive sledgehammer like the Emergencies Act to shut down protests. Now, for those of you who, haven't been paying attention to how extreme the Emergencies Act is, it's really extraordinary legislation. It it does allow the federal government, once an emergency is declared, to create new criminal law by executive order without advance notice, without parliamentary debate. It was expressly enacted with clear guardrails to limit how it can be used or abused, because it had its predecessor, the War Measures Act, had been abused. So it has different types of emergencies, and for what are called public order emergencies, which is what the Trudeau government called the Freedom Convoy, that law, the ability to invoke, it's only available when a really high threshold is met, when there is a threat to the security of Canada that cannot be resolved with existing legal tools. And Justice Mosley correctly characterized this as a tool of last resort. Justice Mosley, of course, is the judge who heard this case. Now, this decision is a complete repudiation of the government's position and a massive political humiliation. Basically, they lost on every possible measure. So let's go through some of those measures. First, Justice Mosley said there was no national emergency. Section 17, sub 2, sub C of the Act requires that if the effects of the emergency aren't affecting all of Canada, the area that is affected needs to be specified. You need to, narrowly carve out where this applies. And instead, the Trudeau government invoked the act nationally, claiming that the emergency existed throughout Canada. And the court said that this was an overstatement and that the government knew that the emergency, to the extent that there was one, did not apply in all of Canada. Justice Mosley held that the majority of provinces were actually able to deal with the protests using, the criminal code or their own emergency legislation. Justice Mosley said that because of that, because there was no national emergency, the invocation was unreasonable and outside the scope of the government's authority. And he said he could decide the case just on that basis alone. But to really hammer the point home, he also found that there was no threat to the security of Canada. This is a phrase that has a defined meaning in the Emergencies Act. Its meaning is the same as in the CSIS Act, another piece of legislation. In order to constitute a public order emergency, which is how this protest was characterized, there needed to be, under the statutory definition, the definition in the law, there needed to be a threat or use of serious violence against persons or property for a political or ideological purpose. And Justice Mosley wrote that there is only room for a single interpretation of that statutory provision. The meaning of threat to the security of Canada has the same meaning as it does in the Emergencies Act as it does in the CSIS Act. And we know that the head of CSIS testified at the Public Order Emergency Commission that there was no threat to the security of Canada. The only specific example of any threat of serious violence provided by the government was in Coutts, Alberta, where arrests were made by the RCMP using the criminal code. And I think it's really important to emphasize this point on the meaning of threat to the security of Canada, because the government, the Trudeau government, has been telling us that there's sort of this myriad of meanings, including economic harm. And the government has restated this today. In a press conference following the release of this federal court decision, Minister Chrystia Freeland reiterated this sort of gaslighting false claim that economic harm can constitute a threat to the security of Canada. If you think about what that means, it could mean that the Emergencies Act could theoretically be invoked to address something like a labor strike, which is intended to cause economic harm. And that's obviously a very troubling idea. So Justice Mosley found that the harm being caused to our economy, because there were blockades at the border, there was businesses shut down in the downtown core of Ottawa. He said that is very real and it was concerning, but he said it did not constitute threats or the use of serious violence to persons or property. And it didn't meet the statutory definition. And without a threat to the security of Canada, the invocation of the Emergencies Act was unreasonable. So in addition to finding that the threshold to invoke the act wasn't met, Justice Mosley also found that the regulations enacted under it were unconstitutional. So once the public order emergency was declared in February of 2022, Cabinet created regulations that prohibited participating in or supporting or traveling to a gathering that could lead to a breach of the peace. And it also created regulations to freeze bank accounts of, quote, designated persons involved in the protests. And the court found both those measures were unconstitutional. The gathering prohibition was an unjustified limit to freedom of expression. It had the effect of criminalizing attending at a protest by anyone, including peaceful protesters just standing silently on Parliament Hill with a sign. And Justice Mosley also found that the freezing of bank accounts was an unreasonable and unjustified search under Section 8 of the Charter, which is the part of our Charter that guarantees our privacy rights. He wrote that financial records are part of our biographical core of personal information, and it can reveal personal details about someone like their financial status, their wealth, their lifestyle choices, and things like that. And the suspension of bank accounts and credit cards didn't just affect people involved in the protests, it affected their spouses if they had joint bank accounts. And that did happen. It happened to one of the individual applicants in this case. And Justice Mosley found that there was really no effort made by the government to address that problem of sort of cutting out your spouse if they were back home in Alberta and you were protesting in Ottawa from your wife being unable to pay the mortgage or buy groceries. Even worse than that, Mosley found that there was no standard applied to determine when someone should be a target of this freezing or how to, appeal that decision if it had been made. And he described the process for freezing accounts as the police just making it up as they went along. So the outcome in this case is obviously very different from the Public Order Emergency Commission's decision, the Rouleau inquiry, but the important difference is that this case has the binding weight of precedent. Now, the government has already said they plan to appeal, but given how detailed the reasons are in this decision, I think that they are going to have a mountain to climb. But we are ready to fight the appeal. If you want to support that fight, you can visit the ccf.ca/donate and help us pay for our legal bills associated with this case. Anyway, I'm thrilled with this update. I hope you are too. I'll link to the decision below so you can read it yourself.